Buenas tardes, gracias por venir. Es un gran placer y un honor presentar al profesor Adrian Vermeule para compartir un rato de reflexión sobre lo que se llama el constitucionalismo del bien común. El profesor Vermeule se graduó en Harvard, primero en Filología y Estudios Orientales, y luego posteriormente en Derecho. Fue clerk, letrado asistente del juez David Sentel en la Corte de Apelaciones del Distrito de Columbia y posteriormente del magistrado Antonín Scalia en el Tribunal Supremo norteamericano. Posteriormente comenzó la docencia en la Facultad de Derecho de la Universidad de Chicago, incorporándose a la Facultad de Derecho de Harvard en 2008. Desde 2016 es titular de la cátedra Ralph A. Tyler de Derecho Constitucional, que es probablemente la más prestigiosa en este ámbito en todo Estados Unidos. Podemos citar a algunos de sus predecesores en esa cátedra, como pueden ser Lawrence Tribe y John H. Eli. Es uno de los principales maestros del derecho público norteamericano y autor de obras de referencia, por citar algunas, The Constitution of Risk, Law and Leviathan, Redeeming the Administrative State y algunas otras. Pero el tema del que nos va a hablar hoy es uno distinto, el constitucionalismo del bien común, que es particularmente interesante. Desde su publicación hace un par de años, aunque venía de un artículo anterior, en 2020, sobre el tema, ha generado un intenso debate académico en el ámbito anglosajón, habiendo merecido muchas jornadas específicas y muchas publicaciones debatiendo la idea y la propuesta del constitucionalismo del bien común. Hay algunos monográficos de la Harvard Journal of Law and Public Policy y The American Journal of Jurisprudence y muchos otros sobre esta materia, que los principales jurispublicistas del mundo anglosajón, no solo norteamericano, también inglés, están debatiendo, con un rigor y una libertad llamativas, la teoría del profesor Vermeule sobre el constitucionalismo del bien común. Yo no voy a entrar a analizar qué implicaciones tiene el recuperar para el derecho público contemporáneo la tradición jurídica clásica y la centralidad de la noción del bien común, pues precisamente de esto es de lo que nos va a hablar el profesor Vermeule. Sí me gustaría, no obstante, resaltar tres aspectos que me parecen interesantes en esta investigación iniciada por Adrian Vermeule. En primer lugar, creo que su planteamiento nos proporciona una lección de carácter metodológico. Así, cuando en el contexto norteamericano la disputa ideológica entre progresistas y conservadores se proyecta en el mundo del derecho como un debate entre partidarios de la interpretación evolutiva de la Constitución y partidarios del originalismo, Vermeule propone una ampliación de la razón para ver qué nos dice la tradición occidental al respecto. Entonces, y eso, ver si la tradición clásica del derecho natural permite una respuesta mejor a los interrogantes planteados. Y así como la discusión entre interpretación evolutiva y originalismo está fuera de nuestro debate jurídico, me parece que es aplicable la lección sobre la importancia de huir de falsas dicotomías y buscar cómo aplicar la tradición a los problemas de nuestro tiempo. En segundo lugar, me gustaría resaltar algo que constituye un elemento importante del libro de Adrian Vermeule. Y es que se trata de una teoría descriptiva y no meramente prescriptiva. Es decir, que no se limita a señalar que el bien común o el razonamiento jurídico clásico deben ser recuperados para una mejor fundamentación de nuestras instituciones jurídicas y políticas, sino que muestra cómo, en cierto sentido, este razonamiento ha impregnado la obra de los juristas prácticos a lo largo de siglos, a pesar de que las doctrinas jurídicas de moda miraran con desprecio el justnaturalismo clásico. De ahí que parte del contenido del constitucionalismo del bien común sea dotar de mayor consistencia teórica al modo propio de razonar de los juristas y, de nuevo, mostrando cómo la tradición permite explicar mejor en qué consiste realmente el derecho. Y, por último, destacaría la humildad intelectual propia del verdadero universitario. Hay muchos ejemplos de esa actitud del profesor Vermeule, pero teniendo en cuenta el foro en el que estamos y, la importancia que tiene en esta universidad el cultivo de los estudios de Santo Tomás, me centraré en uno. entre los académicos norteamericanos es extraña la cita de autores extranjeros y mucho menos de las obras que no están traducidas al inglés. Sin embargo, el profesor Vermeule ha mostrado una más que notable curiosidad intelectual por la doctrina española del derecho natural de raigambre tomista. Y baste citar, ¿no?, por ejemplo, el aprecio que muestra el profesor Vermeule por la obra de Javier Hervada. Y bien, termino como comencé, agradeciendo al profesor Vermeule su presencia en esta tarde entre nosotros. Cuando el profesor Fernando Simón, de la Universidad de Navarra, de donde viene ahora el profesor Vermeule, y yo nos pusimos en contacto con él para proponerle un viaje académico a España, no solo contestó inmediatamente de manera afirmativa, sino que ya directamente ¿no?, cambió los billetes que tenía para Italia para un viaje que tenía en estas fechas para poder ajustar la presencia entre nosotros, ¿no? Yo le agradezco profundamente su disponibilidad, ¿no? Adrian, thank you for your availability and generosity in joining us this evening. So the floor is yours.
Antes de dar la palabra al profesor Vermeule, querría apuntar dos cosas. Una primera, que es la justa gratitud a la Universidad Abat Oliba, aquí en Barcelona, por esta acogida, por cedernos este espacio, por tener esta oportunidad. Por lo tanto, reitero mi agradecimiento a la universidad que ha prestado este aforo. En segundo lugar, por supuesto, a todos los asistentes y también la presentación, de algún modo, de Derecho y Libertad. Es una asociación que digamos, de reciente nacimiento, apenas tiene un año, pero que tiene una vocación de presencia en la vida pública, en su dimensión jurídica, muy consciente de que lo que está en juego en el ámbito jurídico, con la independencia del derecho, con la lucha por el derecho, es fundamental, es decisivo para los momentos en los que estamos. De aquí que hemos tenido la fortuna, y por eso también nuestro agradecimiento, de contar con el profesor Vermeule para estar aquí, pero que, digamos, que digna, en este sentido, presentación de esta Asociación de Derecho y Libertad, a la que desde ahora, quien quiera tener información, por favor, se puede poner en contacto con nosotros, desde luego con Pablo Nuevo, que es secretario general y profesor de la Casa de Derecho Constitucional, y secretario general de Derecho y Libertad. Profesor, ya no eres profesor de aquí.
Bueno, más o menos.
¿No? ¿Qué cuentas? Esto es una novedad que no sabía.
Sí,
en fin.
Pero
que hasta hace poco ha sido profesor
el refranero español es muy sabio
en esta casa, pero yo creo que sigue siendo conocido, ¿no? Y nada más que animaros a, digamos, a partir de esta elección del profesor Vermeule, por favor, a tomar conciencia y la importancia de asociarse para defender justamente aquellas cosas que dan nombre a esta asociación, para defender el derecho y la libertad. Y ya sin más.
Adrian.
Thank you so much. Well, first of all, thank you all for having me, and thanks to my distinguished fellow panelists for helping me talk about the book. And I want to also start with an apology to my new friend, Roger Boada, who is here somewhere, who has heard this exact talk 2 days ago at Navarra, so apologies. It's fun to be here and to talk about this with you. I do very much think that the path forward for American constitutional law is to incorporate the principles and insights of the whole European legal tradition to kind of help us understand what we're doing with our law, to the point where last year I made my students in my seminar start the whole class by reading Javier Hervada's short introduction to law so they can start with intelligent ideas. Okay. My theme today is going to be a little different than laid out in the brochure. My title is Non Nova Sed Nove, not a new thing, but in a new way. And this is the spirit of the talk. This book, Common Good Constitutionalism, is an attempt to translate or adapt the classical legal tradition to our current world. So I want to try to reconnect American constitutional law, but also Western constitutional law generally, with the broad history and tradition of the mainstream of the European legal tradition, the jus commune, which I think includes the Anglo-American common law as a local variant. So the distinction between the common law and continental law is vastly overstated, and that seems to be the recent trend in thinking among legal historians. So the overall aim is in some way to re-enrich legal theory. It's to make it broader, more continuous with the history of Western law and the history of the jus gentium, the law of nations, in a sense make it more inclusive. Of course, the point is not a simple return to the classical legal tradition in the sense of its first order particular legal rules. No one is proposing that. But what that tradition holds are theoretical insights and jurisprudential principles that can be revived, adapted, and translated into our world. Those insights are not so far away that we can't recover them. In fact, and as Professor Pablo Nuevo Lopez said, those insights are already close at hand. They're just somewhat obscured from our current vision. So one of the core claims of the book is that key elements of the classical view of law are already today vital within our law and legal practice. It's just that they're not always recognized as such. So Goethe famously said the classical law is like a duck that dives under the water and resurfaces and dives under the water and resurfaces. And I'm told that in the south of Spain there's a river famously that goes underneath and comes up. Yes, and this is how I see the classical law. It's always there. It's just sometimes we aren't aware of it or can't see it. I think the possibility of such a recovery is itself built into the tradition because the tradition distinguishes what is universal and enduring from what is local and particular. So the major texts of the tradition begin by pointing out that the law has both a general part and a particular part. The general part is common to all polities and includes the natural law and the law of nations, which are ipso jure, they're law of their own force, and a particular part, the positive civil law, which varies across polities and is created by determinatio of the competent lawmaking power. So Gaius says, all peoples who are governed under laws and customs observe in part their own special law and in part a law common to all men. The particular part is the jus civile, and the general part, which he says natural reason has established among all human beings, is among all observed in equal measure and is called jus gentium, as being the law which all nations observe. So my project has a general part and a particular part. They are detachable. You need not have particular interest in American constitutional law if you don't want to, there's no reason you should. But the intention of the book is precisely not to be kind of parochial to the United States. It's quite the opposite. That is, the general part or methodological framework is not at all specific to the American case, and the point is to draw upon the classical tradition in order to illuminate our law. I think this hope of a kind of translation or adaptation / recognition of the law is also itself built into the tradition. The example I'd like to give is the work of Baldus de Ubaldus, who adapted and translated the classical law, the principles of the corpus juris, for the very different circumstances of the independent city-state republics of northern Italy in the 14th century. Baldus doesn't say that, oh, well, we just need to directly adopt every feature of, the Roman law of commercial contracts or something. That would be kind of absurd. That would be like saying that we should all go around wearing togas or something. That's not the point. The point is to adopt the principles and the sources and the methodological framework of the classical law for different circumstances. And so, as others have observed, this concept of non nova sed nove is one that itself already appears frequently throughout the history of the tradition. Okay, so much for the preliminaries. I want to start with a crucial point that Pablo Nuevo already emphasized as well, and I want to be very clear about this. The common good in the legal sense is always already present in our law. It's always already a legal concept, not just a philosophical or sociological or political theory concept. So I follow Michel Villet in thinking that we shouldn't see the common good as at least solely some external concept used in sociology or even used in jurisprudence and philosophy of law. It's a working, practical legal concept within legal systems. It's used by judges and lawyers explicitly or implicitly all the time. It's ubiquitous. It's embodied in the language of enacted provisions and judicial doctrines. Lawyers are constantly working with provisions of a code or jurisprudential doctrines or in a common law system case law that refers in terms to the common good, the public interest, the general welfare, public order, similar terms. And the comparativist Elizabeth Zoller has done wonderful work showing that all these concepts are descended, they're all a family, they're all descendants of the original concept of res publica and utilitatem publicum in Roman law. Let me give some examples of this just at a very practical level. I'm from Boston in the United States, so I have to mention this in every talk. The world's oldest functioning written constitution is the Constitution of my home state of Massachusetts. It was enacted in 1780. And it was often cited as a model for our national, or that is federal Constitution of the United States. The Massachusetts Constitution starts out by saying all shall be governed by certain laws for the common good, that government is instituted for the common good, for the protection, safety, prosperity, and happiness of the people, and not for the profit, honor, or private interest of any one man, family, or class of men. We see here immediately in 1780 the classical opposition between the common good and private benefit or private advantage, which is, of course, rule for private benefit or private advantage is the classical conception of tyranny. And then our national constitution in 1789 said that the kind of master aim of the Constitution is to promote the general welfare, and uses this language elsewhere in the Constitution. This language influences provisions around the world. I think first written constitution in Europe, depending on how you define it, is the famous Polish Constitution of 1791, which specifies that it's made for the general welfare. And then we see influence in Latin America throughout the 19th century. We have provisions like the general welfare provision in the Argentine Constitution and elsewhere. Where do these concepts come from? They're not Enlightenment concepts. They go back as far as we know in Western law. They go back to the etymologies of Isidore of Seville in the 7th century, which says that a law properly so called is an ordinance formulated not for private benefit, but for the common advantage, communis utilitas, of the citizens. And that in turn goes back right to the very beginnings of Roman law. We have this famous injunction or claim of Papinian in the Digest, that the validity of the law made by the urban praetor, the so-called jus honorarium, is that it serves the public interest, utilitatem publicum. And Papinian says a praetorian law, this jus honorarium, is that which in the public interest the praetors have introduced in aid or supplementation or even correction of the civil law. And this basic approach becomes completely standard for civilian lawyers, not just in the Roman Republic, but in the Principate, the later Dominate, in the medieval jus commune, and into the Anglo-American law. And in general, as people have pointed out, Roman jurists spend a substantial chunk of their time making this concept concrete, workable, and practical. Now, with apologies to the philosophers of law, a corollary of this view is that construing legal provisions or working with legal concepts of this sort is not like doing straight philosophy or theology. That is, the provisions or doctrines are not directly or wholly open to philosophical debates over the common good. The example I give here is if you go to the western deserts of the United States, well, if you go, please be careful, bring water with you. But if you go to the western deserts of the United States in places like Arizona, Nevada, or California, you will see there's a certain style of architecture where they have houses with no walls. The houses are completely open to the breeze, and that's in order to cool off the house. Law is not like that with respect to philosophy. That is, the breeze of philosophy does not blow directly through law. Laws and this legal concept of the common good is partially independent of the underlying philosophical concepts. And the reason for that, in my view, is, as Ronald Dworkin said in his last book, I think he got this correct, finally. He said, law is a distinctive and rather strange department of political morality. It's the art or craft of practical reasoning about legal justice that takes into account distinctive considerations arising from the institutional embodiment of the legal system. That is, law is always caught in a kind of tension, but it's a good tension, productive tension, between reason and fiat, between pure norms and their institutional embodiment. So law in this sense is like the Roman god Janus. It has two faces. It faces both ways. And I love a dictum of Paul Ricoeur, who said exactly this. He said, justice looks both ways, to law and to the good, and it's kind of always caught between them. So the legal common good is embedded in practice and practical reasoning, and it's in this constant, never-ending negotiation with institutional roles and institutional constraints. So imagine if you're a working lawyer or judge and you're faced with a provision that says the common good or public interest or public order or general welfare or something in this family. What you can't do as the working lawyer or judge is to sit back and express a kind of general skepticism about the common good or about its determinacy. I don't know what it means. It's very complicated. You have to make it mean something or understand it to mean something. You can't simply say, who decides? Well, the community of jurists decides. So the working lawyer or judge doesn't have the luxury that academic theorists have, including academic legal theorists like me. They don't have the luxury of the endless conversation. At some point, the conversation has to stop, and some interpretation or other has to be offered. Now, one way the lawyer or judge can lighten their own burden, and this is very important, is to interpret the provision as commanding some version of a margin of state discretion or a margin of appreciation. So my claim is not that judges decide everything, and I'll talk about this later. But that, too, is a legal interpretation when we include a margin of state discretion or a margin of appreciation. That, too, is arrived at through practical reasoning in a larger institutional order. Okay, so we have this common good within law as a practical concept, and we have to ask, what exactly does the classical tradition hold about legal interpretation and legal adjudication in this world? It holds the following. It says that the work of law is a practical art or craft of reasoned ordering to the common good. It's the ars boni et aequi, or art of goodness and fairness. It's a practical art of purposive and reasoned governance that in the temporal order promotes the good of law's subjects as members of a flourishing political community, and ultimately as members of the community of peoples and nations. All officials have a duty and a corresponding authority to promote the common good, although they do so in a manner consistent with the requirements of their roles. That is, the lawmaker doesn't do it the same way the judge does it or the police officer does it. They all have distinct roles, but within those roles, they all have a duty to promote the common good. So this classical conception embodies a certain regulative ideal. It's one of these ideals that is partly aspirational, partly descriptive. It's always somewhat disappointed, but we always keep coming back to it. And the regulative ideal is the union of well-ordered reason with public authority, the union of reason with fiat. Okay. Now, classical law treats enacted texts in light of this background in a certain way. It treats them as determinationes. It treats them as instruments that give more specific content to general principle drawn from a higher source of law, making it concrete in application to particular circumstances or problems. The virtue that is necessary to make reasoned determinations is of the virtue of regnative prudence. This is the subtype of prudence particularly appropriate to those charged with care of the community, public authorities, according to the requirements of their different roles. And the need for determination arises when principles of legal justice are abstract. They don't directly dictate particular legal rules, or when those principles seem to conflict and have to be mutually harmonized. So there are typically multiple ways to determine principles while remaining within the boundaries of the basic charge to promote the common good. And I adapt one of Aquinas' analogies, and I give the example of an architect who's given a commission to build a hospital for a city. And an architect with a commission like this has a kind of structured discretion. It's both discretionary and structured. The purpose or end, the telos of the commission, shapes and constrains the choices the architect can make, although it doesn't fully dictate them. Just in the same way, a hospital can take a number of forms, although there are some forms a good hospital can't take. So too, if we we recognize a natural right of self-defense, for example. Well, doing so doesn't tell us what we need for practical working law. We have to answer all sorts of further questions in order to determine, make more concrete the natural right of self-defense. If you attack me with a weapon, but I can easily run out the back door, am I allowed to counterattack you? Maybe, maybe not. We have to get the law down to the ground in this sense. And that is the primary function of the civil lawmaker. I love this way of putting it by Jean-Étienne Marie Portalis, who is the main drafter of the first draft of the French Civil Code in 1801. He said, and this is like the god Janus again, he said, human lawmakers look both ways. They're both giving specified content to the positive civil law, but they're also looking upwards and interpreting principles of natural equity. And their function is to harmonize both of these in a union of reason and fiat. Okay, so sometimes the classical legal tradition is accused of not taking the text of the law seriously enough. I emphatically reject that view. The judges or other officials who interpret law at the point of application are duty-bound to respect the text of the law. But this isn't a kind of mindless literalism. It's not text without mind. It is a mindful textualism that understands the text of the law as a rational ordering of rules to the common good by the public authority. So the text of the civil law is always read against the backdrop of and read to harmonize with the broader legal background of sources of natural law, general and traditional legal principles, where appropriate, the jus gentium. So the classical law treats the positive civil law as terribly important, but it's part of a larger cosmology of law, and the impulse of the classical lawyer is always to harmonize these in a coherent framework. So, of course, in what Dworkin called hard cases, where the positive lex, the written law, is ambiguous, vague, or general, or seems to be internally incoherent or something, of course, we consult these broader array of sources in order to make sense of the positive civil law. That, I think, is pretty straightforward. But I also want to emphasize that even when we just try to read the semantic meaning of any law, even in what we might call an easy case, we read it as an ordination of reason. Often implicitly, so we sometimes don't even realize we're doing this because the assumption runs so deep in us that this is how law should be read. Richard Helmholtz puts it like this in a wonderful book on natural law in court. He says, the law of nature and the broader suite of sources in the classical tradition play an internal role. They're used to discover the very meaning of existing laws. Let me just give a concrete example from the digest from the Corpus Juris, and there's a wonderful, famous discussion of the interpretation of the lex aquilia. And the text of that law provides as follows. It says, if anyone kills unlawfully a slave or female slave belonging to someone else, then an action for damages would lie. Okay, so if I unlawfully kill your slave, then you can sue me for damages. But Gaius comes along and says, well, wait a second, what about a case where, strange case, but your slave is lying in wait, lying in ambush to kill me. May I kill your slave? And he says, yes, you may, because naturalis ratio, natural reason, permits a person to defend himself against danger. So this is the natural right of self-defense again. So here Gaius is using natural reason to interpret what counts as unlawful within the meaning of the text. Often people get far too obsessed, in my experience, with the kind of case that later natural rights theorists would discuss, which is the question where of a positive civil law that seems unambiguous and contrary to some higher law of nature, and they get obsessed with the question of the hierarchy of legal sources. The main emphasis in the classical legal tradition is not on this. The main emphasis is on internal harmonization. And this harmonization occurs through presumptions of law, what in the Anglo-American tradition we call canons or maxims of legal interpretation. The classical lawyers would call them reguli juris. And these have a kind of function. They attribute to the lawmaker a reasoned execution of the lawmaking office. They assume that the lawmaker is enacting an ordinance of reason for the common good. They're partly fictional, but I don't think that legal fictions are bad. They are necessary and ubiquitous. They are normatively inspired regulative ideals about how lawmakers behave. And these reguli juris are so deeply embedded in our natural way of thinking about law that we often don't notice we're using them. So, we do not lightly assume that the lawmaker is a sadist and is trying to punish people arbitrarily. We don't naturally or lightly assume that the lawmaker was making a joke or was legislating in a foreign language, or was engaged in self-dealing, or intended to create some Kafkaesque system. We simply assume, even without thinking about it, that the lawmaker has some rational and public-spirited aim in view. And one of my conflicts with certain other American legal theorists is that the judge for whom I clerked, Justice Antonin Scalia, in my view, made exactly this argument. So when he talked about textualism, he meant textualism in the classical sense, textualism that always already assumes that there's a rational public-spirited end to the text, not that the text is some collection of letters that can be read independently of this background. Okay, how does judicial review, say by a constitutional court, work in this system? We have to keep separate two distinct issues. One is how a written constitution should be interpreted, and two, what the scope and method of constitutional review should be for judges with their specific roles in a legal system. Let me just illustrate with the case of the classical American conception of constitutional review, where we can see that these two ideas, how a written constitution should be interpreted and what the judge's role is, come somewhat apart. They're not just the same thing. So the classical framework for constitutional review in the United States was this: if the public authority acts within its constitutional sphere of competence, it can act on a reasonable conception of the common good, any reasonable subconception or determination of the common good, by reference to the legitimate ends of government, health, safety, and morals. And where it does so, where it makes a kind of reasonable, not an arbitrary determination about the means to promote health, safety, or morals, the judges have to defer to it. So that the primary role of making the determination of higher sources of law is vested in the legislative body, in the public lawmaking body. So I say this because sometimes people say that I am urging judges to be philosopher kings. With all due respect, again, to philosophers, it's quite the opposite. Okay. I haven't said anything yet about the kind of pure concept of the common good, because I wanted to start by stressing the point that the common good is partly independent of philosophy and is an internal concept within the legal system. But I'll just use a last few minutes to explain that I hold what I take to be the ordinary classical conception of the common good, which is not a mysterious one. It starts with the following premise given to us by Marcus Aurelius. It's a metaphor about a beehive. And he says, what injures the hive injures the bee. What injures the hive injures the bee. What is the point of saying this? The point of saying this, I think, is quite deep. It's to say the common good is not opposed to the good of individuals. It's a mistake to think we have the good of individuals here and then we have to override their good for the sake of the common good or the general utility of the whole political community. That's not right. That's actually a Benthamite utilitarian view, which often appears in liberal legal theories of rights, and I reject it. Rather, the classical concept of the common good is that in the temporal order, a well-functioning political community is itself the highest temporal good, even for individuals taken one by one. So the common good of felicitas or eudaimonia in a flourishing political community is ultimately for the sake of individuals. It's ultimately for the benefit of individuals, because a flourishing community is the fundamental precondition for all other goods of individual and family life. And so this yields the so-called distinctive view of the common good. The common good is unitary and indivisible. It can be shared without being diminished. It's not like a cake where if we share it, you eat your piece, you eat your piece. It's not like that. It's more like the victory of a sports team that is a victory for each, but it's also a victory for all. And it's shared among the team without being diminished. Or a beautiful public park, which, at least within certain limits, can be shared. You can enjoy it and I can enjoy it, and my enjoyment doesn't take away from your enjoyment, subject to conditions of public order. Okay, this concept of the common good, I think, is very deep within the classical legal tradition. And I just want to explain how it works its way into the legal tradition very briefly, and then I'll be done. Let me start with this famous explanation by Ulpian of the precepts of use, of juris. He says, juris praecepta, the precepts of the law are this, or the precepts of right are this: honeste vivere, to live honestly; alterum non laedere, not to harm others; suum cuique tribuere, to give to each their due. The reason this is so wonderful, in my view, is because if you try to subtract from it, you end up with an incomplete formulation of the goods of political life. So, for example, if you just take alterum non laedere, which is an important principle, it's not wrong, but if you take it by itself, you end up with a kind of John Stuart Mill libertarianism, which says that subject to the constraint of not harming others, everybody should be able to kind of author their own life plan. And I think that that's an incomplete account of the political common good. And it's incomplete because it leaves out two fundamental principles, Ulpian's other principles. It leaves out the positive duty to give to everyone what is due to them in justice. And secondly, it leaves out this maybe even more fundamental idea of good faith participation in the political community, which goes well beyond not committing fraud. It suggests that we all have obligations in good faith as members of a community, that what I do affects your life and vice versa, and that we have to understand that no man is an island, as John Donne said. Ulpian's formulation leads to another famous formulation in the Jus Commune, the famous trinity of pax justitia and copia, peace, justice, and abundance as the ends of civil government. This is so famous that Innocent IV puts it on a coin and makes sure everybody sees it. I tried to get that as the cover for my book, but they thought that was too obscure and reactionary or something, but it's a wonderful coin. It's online, so please look it up somewhere. And that formulation, pax justitia and copia, then gets directly embodied in legal provisions all over the world, even in the Anglosphere. So it's the ancestor of the peace, order, and good government language of the British North America Act of 1867, which is a fundamental legal instrument in North America. Okay. I guess I'll just end with one last word, and then I'll be done. To forestall any misunderstandings, what is the role of rights in classical legal theory? It very much has a role, and it's a misunderstanding to think that rights are not present in classical legal theory. The thing, though, is that rights are justified in a different way. Often in liberal legal theory, rights are seen as something held by individuals that trumps the interests of the collective. Or at least that's the debate that's set up. Should the collective prevail or should the individual prevail? That is not the way the classical legal tradition thinks about rights. Because the common good in the temporal order is itself the highest good of and for individuals, the common good enters into the definition of rights right from the beginning. So the rights of individuals are recognized insofar as doing so contributes to the common good. and the common good is built inside rights from the ground up, as it were. Rights are objective corollaries of duties, duties of legal justice, which is the constant aim of giving every person their due. Use, in the sense of right, is what is due to every person in justice, and that includes rights. Some examples I'd like to give are that from very early in Western law, it's recognized that retroactive legislation is presumptively suspect. I mean, this goes back to the Code of Theodosius and Valentinian, and is embodied in later codes as well. And it's understood that it's a problem for individuals to comply with future retroactive changes in law because no one is obliged to comply with the impossible. Another one is that the classical law put great stress on affording a hearing, some kind of hearing before a judge or something, before property or liberty could be deprived. Why was this? Well, it's not some kind of theory that you would hear today about individual autonomy or some such. Dick Helmholtz points out, tongue slightly in cheek, that the classical lawyers justified the right to a hearing by pointing to the third book of Genesis, in which the omniscient God, omniscient deity, affords a hearing to Adam and Eve before he punishes them, even though he knows exactly what they've done. And he does so on the basis of use of right. So rights are present very much in the classical legal tradition. They're just conceived and justified in a different way. Okay, I think I am done. Thank you. Yeah. Thank you.
Thank you so much, Professor Vermeule. Ahora tenemos un turno, tenemos tiempo para abrir preguntas al profesor Vermeule. Ya sea quien quiera hacerlas, tiene ahí el micrófono. Si las hacen en inglés, pues estupendo. Y si es en español, el profesor por lo nuevo hará la traducción.
Okay, no. Thank you very much for your explanation. I think it's the topic is really interesting. Actually, I have the book, so you
Good. Thank you.
You can imagine.
Sorry, what is your name? I like to meet people.
Luis Gaspar.
Nice to meet you. Yes.
Sometimes I really struggle with the idea of common good when it comes to this virtue of prudence and the determinatio, the idea of when you have a problem and which principles apply and everything. And I think sometimes it's very difficult to when it comes to a state, to a national level, to really apply these kind of ideas, because you can always say that you are trying to serve the common good and you are using some principles and you cannot really control this process. What I mean is virtually any politic could really say that they are trying to help the common good, and it's really difficult to control these processes. That's I'm under this impression. And of course, in your book, you try to explain some cases that you apply this determination, but I don't really know how can you really apply it in a national level, or how can you really use it without really manipulation or something like that, because people will always try to say that they are trying to serve the common good. That would be.
Good, thank you. This is a very legitimate concern, and it's such a legitimate concern that it's exactly the concern I have about liberal legal theory. So let me explain. I'm going to take your question, and instead of the common good, I'm going to plug in some other formulations. Liberty, the free development of human personality, equality. And I am never quite sure how we can control judges who draw upon these concepts in either mysterious ways or sometimes I suspect, in perhaps not in perfectly good faith. Let me put it that way. So you obviously see the point of my response. The problem you mention is real, but it's a real one for any constitutional theory. That is, the problem you're raising is not unique to classical legal theory. It's actually a much deeper problem. It's the problem of how any constitutional theory can kind of guarantee the conditions for its own good faith enforcement, if you like. And the answer is that it can't. It's not the province of constitutional theory to ensure the conditions for its own good faith enforcement. That is, if we live in a polity that has come to such a bad situation that judges will simply and cynically use the law as a poison dagger for factional conflict or for sectarian ideas, if they'll betray the integrity of the concepts they're working with, then arguing about legal theory is not going to help us. We have a much deeper problem that needs to be addressed on a deeper level. To put it yet another way, I think that, although I am a law professor, I don't think that law professors are the kind of sovereign legislators of the world. I think our work only matters within a kind of intermediate band. The intermediate band is you have a society that still has enough kind of communal feeling, enough good faith that you can meaningfully discuss the differences between legal theories and come to some kind of good faith implementation of those theories. If you lack that, then this book will not help you. Although, please still buy it. Yeah.
I did it.
Thank you.
Thank you.
Already done it.
Yeah. Okay. Yeah.
Good afternoon. My name is René Tapia.
Nice to meet you. Yeah.
Nice to meet you too. I want to ask you a question, a personal view regarding the future. Do you think that liberal theory of law is going to be the next Asian regime? And if that's so, do you think that classic natural law approach to power and law could have a decent spot in this super interconnect, globalized world with superpowers in Asia that are not bound with this tradition?
Well, so this is a great question, and it calls for partly an answer within my own competence, which is the U.S. case, and partly an answer outside my competence. I'm going to say something about the global South and the role of the common good. Within the U.S. case, I'm extremely hopeful. I mean, it is already true, and it's very striking and surprising to me that the younger generation of law professors, lawyers, government lawyers in the United States are already completely fascinated with the classical legal tradition. They are expressly reviving it in all sorts of ways, and that they will have tremendous influence over the law in coming decades in virtue of judicial appointments that will be made in the next 4 years and beyond. So in the United States, this is already very much a thing, much to my pleasant surprise. I didn't expect that would happen so quickly, but it's happening. Now, let me say something about the Global South. I had a terribly interesting conversation with some scholars from places like Sri Lanka, Asanga Velikala, places like Singapore, and places from mainland China, who are in their own ways, actually pursuing the enormous common ground between the Western classical legal tradition and the classical Chinese philosophical and legal tradition, which has something that's very close to the Western conception of the common good. So if you look at something called the Book of Rights, the Li Ji, there's an idealized conception of the public order that's called Da Tong, the Great Harmony. And this, if you kind of investigate it, is very close to the common good regime. And these scholars think that in our current circumstances, in 2024, the kind of idea of the common good, the language of the common good, is actually a hopeful way to provide a bridge between Western traditions and the global South and Eastern legal traditions, because it's something that already exists in those traditions and it's a vocabulary that provides a basis for mutual comprehension. So I'm filled with nothing but optimism, at least today. Talk to me tomorrow, it may be different. Yeah.
Thank you very much.
Yeah.
Thank you, Professor Vermeule. My name is Adrian Rubio.
Nice to meet you.
We met.
Yeah, that's right. Yeah.
Briefly in Boston when
Yeah.
I was at BC. So I have two short questions, but that give me trouble. So the first one is,
Please,
you
yeah.
started by saying that the notion of common good is already legal in and of itself. So it's endogenous to the legal order. My question is then, how would we distinguish different sources of normativity? In other words, how do then distinguish a moral reasoning based on arguing what the common good entails and what we owe one another out of or by virtue of a moral obligation vis-a-vis a legal obligation? So that's the first, because if the notion of common good is already legal, then I think we're like somehow merging the realm of morality with the realm of legality. And that raises concerns, just to even distinguish what the law is vis-a-vis the ethics or of morality. And the second question...
Can I just take them one by one, because it's easier for me that I forget the question. Okay, at my age that happens, so... this is also important, Adrian, fellow Adrian, but I'll say two things. One is I just published a response to a symposium in Oxford where I discussed exactly this question with John Tassioulis. So let me refer you to that. I'll just give you the very brief version. Is I think, unfortunately, the way you framed the question, which is exactly the way John framed the question, begs the question in positivist terms. It begs the question in positivist terms by saying morality is here, legality is here, what is the relationship between them? That is the positivist framing. The classical legal tradition can't answer the question in those terms because it rejects the premise. The classical legal tradition says that, of course, political morality is a broader domain than law. Law is a special subdepartment of political morality, but within the subdepartment of law, there's a subset. So if you imagine a Venn diagram, there's a subset of political morality, which is use, which is principles of legal justice, which are simultaneously both moral and legal. I joke for the theologians, it's a hypostatic union. They're 100% moral and 100% legal, and it would be a mistake to say, well, are they moral or are they legal? And they are identified in the way that we always identify use, through multiple epistemic strategies, through natural reason, through tradition. We think that if something has been identified throughout history and in legal systems across the world as part of natural justice, then it probably is. We'd have to be very epistemically arrogant to say that it wasn't. That is a kind of Burkean point. And by the professional work of jurists. We pay attention to the work of jurists who have spent They have a kind of expertise in identifying these principles. So I don't think that framing is one I can accept, but I do want to emphasize that I think you're right insofar as of course there's a domain of political morality and indeed ethics even more generally that is not part of law. And that is an ordinary idea in the classical legal tradition. So, Aquinas says, of course the law shouldn't try to take within itself and punish or reward all vice or virtue. There's no idea that that's a kind of totalitarian idea that the law should precisely track all of whatever the society takes to be political morality. But it doesn't follow that there can't be something that's both 100% moral and 100% legal. Thank you.
Thank you so much.
Good, yeah.
And then my second question focuses more on the relationship between what it is and what it ought to be.
Yeah.
And how the law can help us navigate that relationship or connection or tension even. Because if common good belongs to the law, and
Yeah.
it is what the law is about, as you said, the Commonwealth of Massachusetts embodies that common good as a principle, guiding principle, or mission even of the entire Constitution, then how do we operationalize it in practice? In other words, if you're a bureaucrat or at an administrative agency, and I know from Law and Leviathan that Fuller is also supporting this.
Yes, exactly, yeah.
But my idea is, don't we end up falling into a naturalistic fallacy somehow if we derive what we ought to give one another by trying to go back to what the law requires, which is paying attention to the common good?
I'm afraid I have to give the same answer to the second question as to the first, which is I think you've put the question in terms that assume away the classical argument. So let me explain. Let me explain by reference to Dworkin. I always get in trouble when I talk about Dworkin because people say, "Oh, you like Dworkin? You must like his views on whatever some crazy legal theory." No, I think Dworkin has good parts and bad parts. And one of the excellent parts of Dworkin, where I agree with John Finnis that he really captures the spirit of the classical law, is the idea of law as caught in a perpetual productive tension between fit and justification. That is, it doesn't sharply separate claims about what the law is from what the law should be. That it's always tacking back and forth between interpretation of the law and evaluation of the law in order to do interpretation of the law. And the reason it's doing this is precisely because of these regula juris that I mentioned, that we attribute to the lawmaker beneficent intentions, that we attribute to the lawmaker a valid execution of the lawmaker's office in making law that's a reasoned ordination for the common good. And so there's no way to even understand what the law is without at least partly, even if only subconsciously, thinking about what the law ought to be. And these are the examples I gave of the interpretive presumptions we always already attribute to law without even thinking about it. Let me just mention one thing that I like to mention in these talks that I think goes a long way towards defending the classical view and kind of undermining this talk of the naturalistic fallacy. It's there's been a spate of recent work in a field called experimental jurisprudence, which is quite fascinating, and I exploit it cheerfully and ruthlessly because it turns out to strongly support the classical view of law. So these experimental social psychologists of law do large number experiments and surveys, and what they found, at least initially, people like Brian Flanagan, is that people think about law in exactly the way the classical tradition thinks about law. So, for example, if you tell them things like, the positive law commands that each father shall execute his own children, something obviously unjust. They don't say, well, that's still the law, although it's an unjust law. They don't separate law and morality this way. What they say is, that's not really a law. Or they say something like, that's perverse. That's kind of a fake law. And this is exactly what Aquinas says, right? That an unjust law is a perversion of law. It's a corruption of law. And it turns out this is the way people think about law, unless you do something very specific and weird to them, is you put them in like a long course of study of law and beat them over the head with Joseph Raz every day. If you don't do that weird thing, then they naturally think about law in these terms. Yeah.
Thank you so much.
Yeah.
My name is Elia Martal. I am from the University of Barcelona. Thank you very much for your talk. I haven't read your book, so I'm afraid my comments are going to be very superficial or just impressions I got from here. It's a very interesting topic, obviously. I think you managed to point out the big problems that we have now in liberalism, as for instance, what are rights, as you were mentioning. Rights are not just the possibility to do whatever I want, because there is a common good that we tend to forget. Like, for instance, what do we do now with climate change? Yeah, can we go on going for having a coffee to Amsterdam for 2 hours and come back? Or these things we have to start limiting on behalf of that idea. The other thing is that I found very interesting is how you insist on the idea that legal institutions have a content, and law is not just simply, or at least this is the impression I get, law is just not a set of procedural rules that allow you to do whatever you want. But at the same time, I'm wondering, are you really proposing an alternative, or are you just pointing out at these contradictions? Because I don't really see how we can transfer the decision-making process to some other institutions that are going to act with this idea of what the common good is. Like, I understand that the legal tradition has tried to defend the idea of common good, but 21st century, is law able to go on functioning with the concept of common good, independent from economists that work with such sophisticated mechanism to try to see what the common good is? And sorry, I stopped.
Okay, I think I understand the gist of the question. Of course, it's against my practice to answer questions from anyone who hasn't bought my book. But I'll do so just this once. I'm kidding. I'm joking. Thank you. Look. I don't think that the idea or the project is best understood as saying how can we transfer authority to a new set of institutions, or how can we replace the current way we think about law with a new way of thinking about law. That's, I think, again, a framing that I tried expressly to reject. My claim is that we are always already thinking this way, and so I sometimes joke that the book is not so much a proposal for a new way of thinking about law. It's not. It's intended as a course of therapy, where people come to see the roots and causes of the behavior they're already engaged in, if that makes sense.
Yeah.
And I would distinguish here sharply between the theorizing of, say, judges when they are trying to reflect in a theoretically self-conscious way about law, and on the one hand, and their actual legal practice on the other. So at least in the United States, when judges reflect in a theoretically self-conscious way about law, they often are completely unable, in my view, to describe what they actually do in their legal practice. It's like, let me give you an analogy. Sir Joshua Reynolds was a famous English portrait painter of Samuel Johnson's time of the 18th century, a wonderful painter of portraits. And then he made the terrible mistake of trying to write a book about painting, to explain painting to people, and his book makes no sense whatsoever. He was completely unable to explain his own masterful practice. This is how I see judges when they're engaged in, not all judges, but sometimes when they're engaged in express theorizing about law. When they actually, put on the robes and ascend the bench and write decisions, often, in fact, I think this is the ordinary case, they are expressly or implicitly already using classical legal concepts, already using regula juris, already using principles of natural justice, already attributing conceptions of the common good to lawmakers in doing this process of fit and justification. So I don't think it's as bad as all that. One final word about economists. I spent the early part of my career arguing with economists. I was at the University of Chicago, and every day I'd have to argue with them. I have great respect for them when they talk about a kind of within their discipline about the particular kind of workings of the price system and so on. But I think they're what you might call political theorizing is just not right. That is, that the aggregative conception of the common good, aggregate utility is overriding individual goods is it's simply hopeless for some reasons I mentioned, and maybe I'll go into it more sometime. Yeah, thank you.
Very much.
Una pregunta más para el profesor Vermeule, por favor.
Good evening. Thank you dearly for your illustration and your portrayal. You've portrayed in the sense that the common good constitutionalism may be embedded within our institutions. If we were to regard artificial intelligence as an institution, it's quite speculative, so bear with my scenario, please. So in the sphere of generative AI, and for the fact that we are aspiring to create this paradigm, reconstruct the distillation of reality, how would you encompass the common good principle into what we may define as the first universal language? Something that's transcending cultures, transcending ethnicity, transcending comprehension.
Thank you. I mean, my basic answer is I'm 55 years old, so I have nothing intelligent to say on this topic. But my secondary answer, I think, would be the following. I think AI, as far as I understand, is quite good at doing certain things. It's quite good at immediately surveying very large bodies of information and extracting patterns from that information. And if my argument is right, then AI could be quite a helpful tool in kind of adapting, translating, reviving classical jurisprudence for the reason I was discussing with other Adrian, which is that the fundamental epistemic strategy of the classical lawyer is to look at a broad section of history or a broad array of polities in their legal systems and to see what is the common ground in terms of attributions of legal presumptions and regula juris, attributions of natural principles of justice, attributions of conceptions of the common good. And an entity that can quickly do that kind of epistemological work, I think is well suited to help us. So again, my American optimism emerges, and I think bring on the AI. It'll be helpful. Yeah. Please, yeah.
Do you believe it could, in a sense, encapsulate or encompass the entire heritage of humankind? Would it need to look into the entire legacy of the classical jurisprudence, of a historical jurisprudence? Or do you think you could align certain more modern contemporary values across the world?
I think it can do what you say. There's a wonderful example just from the public law of the Qing dynasty. I can't remember the names of the parties, but roughly the case went like this. The emperor prescribed a punishment that was outside the legal code, the Qing dynasty legal code. It was too severe. And the jurists immediately went to work with reguli juris to kind of harmonize, civilize, moderate, temper, and domesticate this interpretation. And through a process of presumptive reasoning, ended up saying, no, the emperor couldn't have intended to do something so arbitrarily harsh. What he meant was that the next level down, the Board of Punishments, should consider whether to engage in a kind of departure from the law, and we have considered it, and we've decided that the ordinary, more lenient law should apply. An AI could immediately look at examples like this and, help us find common ground between different legal cultures.
Thank you very much.
Yeah.
Una última, ya la última.
Thank you very much. My name is Veronica Vargas, and I wanted to ask you about the virtue of prudence. Maybe I see the virtue of prudence translated into a policy virtue, which is the precaution. And here in the European tradition, European Union, we have the precautionary principle.
Yeah.
Maybe this question is more related to your other book, the First Constitution. But do you think that maybe common good can be embedded in this way of operationalizing decision making in the Europe sphere?
Yes, absolutely, and I would recommend. So it's well known and indeed, rather notorious that the precautionary principle has come under a lot of fire from decision theorists in various ways because it seems to capture a terribly important intuition that I agree with, but it's a little bit hard to cash it out in a precise way. One suggestion I made in the book, and I left this out of the talk, is that there's an enormously rich heritage in the classical law for talking about the same concerns that animate the precautionary principle, and that could be drawn upon in a way that adapts classical law for modern situations, including climate change, environmental damage, and so on. So, the classical law recognized whole categories of property that were not individual private property, or more accurately, whole categories of things that were not subject to becoming individual private property. So there were different subcategories like common property or res nullius, something owned by no one, and so on. And the Institutes of Justinian is very emphatic that that both the air and the flowing water and the sea are common property, and these kinds of ideas can be easily adapted and drawn upon, and indeed they have been. I think the recent Dutch climate change litigation, if I'm not wrong, drew precisely upon these classical concepts in part to try to establish claims for legal regulation of a common air. So I think that that might be, in a way, almost a more promising way forward than kind of the precautionary principle, but I think it's very much animated by the same concerns.
Okay.
Yeah.
Thank you very much.
Yeah.
Thank you so much.
Yeah.
Professor Vermeule.
Thank you.
I think it's going late.
Yeah. Thank you. Yeah.